Hello, hello, hello. This is Attorney McCord. I'm coming to you from an undisclosed location. Alyssa sent me one which she suspects is a SovCit. My undisclosed location may have been blown. I don't know what I should say here. All right, I'll just do this. I'll pretty much blow it. I spent the morning with monkeys and sloths. I'm not making that up. I did. And I'm not going to lie to you. I was in a sloth sanctuary, and a viewer came up to me and said, "Hey, I know you." And I started my day hanging out with monkeys and sloths at 6:30 a.m. local time. Oh, it's fantastic. It is. Hi, Rocky. It's nice and hot here. You know, it's a climate that has sloths. Let's just say that. All right, that's this. But I will give a big shout out to Sandusky, Ohio. I'll just leave it at that. All right, now let's get back to the business. You guys really don't care where I am anyway. It doesn't matter. I'd open the window. I've got a fantastic view, but it washes it out. So then so now I close the. I'm in a nice room, but it looks like I'm in prison. Don't worry, it's a luxury ride. It really is. Don't worry about it. All right, let's get this going. I want to see if this guy's a SovCit or what the situation is.
Okay, I can't see all of you, Mr. Crane.
You can see me?
Now I can see. That's better. All right. This is in the District Court of Ellis County, Kansas. Case number 24 CR 197, State of Kansas versus Caleb Crane. May I have an announcement of appearances, please?
Please, the court. The state appears through Assistant Ellis County Attorney Joshua Becker. Caleb Crane appears on Zoom pro se.
And you are Caleb Crane?
Correct.
Okay, your box says Jerome Crane.
That's my middle name.
Okay.
Is there a bay?
And following our
Tell me there's a
hearing
bay.
on January 3rd, we are scheduled today for a motion to suppress, correct?
Yes, Your Honor.
Your Honor, for the record, can you please state the title of that motion and the certified mail number for me? I just need to clarify.
I don't understand what you mean by certified mail number.
Well, I file all my motions through a certified mail number, like I have one in front of me from a right here with a file stamp on it, and I have a certified mail number that I filed through the court with the tracking number 9589071.
All right, we're not there yet, but this already feels SovCit adjacent.
05270
I see where Alyssa was coming from.
1868199070. And I was just trying to make sure that you got the right motion.
You had filed a motion to dismiss in this matter back on
I believe November 12th, Your Honor.
November 12th of 2024.
Yes, I filed that motion, and that motion was never heard by the court.
Okay. We had gone through the motion and you had identified this
And it sucked.
by what you put down as quote counts.
I would like
You had count 1 regarding identity fraud. And
Yeah,
you,
but
I mean, like, I don't know. To a layperson, this may or may not sound funny. You don't have counts in a motion. You have counts in a complaint. It's just it's just basics of drafting things, but it's just glaringly obvious to anybody who ever went to law school that you don't know what the hell you're doing.
count 2, dismissed due to illegal search and seizure. And that's what we're hearing today. And you had count 3, speeding infraction should be dismissed.
the prosecution failed to respond to the motion and the court never heard it though.
Well, they did respond to it in arguments on January 3rd.
As well, I filed if I may, Your Honor, I filed my response to his motion on December 6th of 2024. We had sent that by mail and by email to Mr. Crane, or at least.
Please, God, tell me that it says that it contains the line, everything that this guy said is bullshit.
To the address and email we had on, excuse me, on file here in our office for Mr. Crane.
Can I get that motion read on the record just to clarify?
Well, I'm not going to read your entire 62-page motion onto the record, Mr. Crane. The record is the record, and it is filed as of November 12th.
I don't know if he SovCit, but he sure is stupid, and it's already fun.
We dealt with what you called count 1 and what you called count 3 last time. What you have as your second issue, what you're calling count 2, is that the possession of the controlled substance should be dismissed due to an illegal search and seizure of the contraband, which the court inquired of you if you were actually filing a motion to suppress the evidence based on illegal seizure, and you agreed that's what you were intending to do.
I'm not withdrawing any of my motions, Your Honor.
Okay. I'm not asking you to withdraw the motion.
No,
I'm
I was
asking
just
you,
saying I'm not withdrawing any of my motions. I was just letting you know.
I understand that, but your count 2, you're alleging should be dismissed due to an illegal search and seizure,
Sure.
which is a motion to suppress evidence.
No,
And that's what we're here to do, is have the hearing on your motion to suppress that evidence.
and that's what I'm saying. I never filed that motion, Your Honor. Or every motion.
Yeah, and that's what the judge is saying. That's your problem, because what you have makes no sense. What you want to do is suppress the evidence, and then if they don't have evidence, they fail to meet their burden of proof, and then you win. But what you did is just make a claim without fleshing any of it out, and it's useless by itself. So he's trying to help you, and you're not getting it.
That I filed, I have with a certified mailing number. So I'm trying to see where are you getting that I filed a motion to suppress.
He thinks he's going to win this by the certified mail number somehow.
Count what you label as count 2 of your motions document filed on November 12th, 2024. Page 2, you write count 2, possession of controlled substance should be dismissed due to an illegal search and seizure. Okay. Your motion to dismiss due to an illegal search and seizure is a motion to suppress the evidence based on an illegal search and seizure. That's what we're here today for an evidentiary hearing on. your motion to dismiss based on an illegal search and seizure.
Okay,
That's what we're going forward on today.
but that's what I'm saying. I never said that. But could you speak to me in layman terms? Because I'm not understanding.
I'm speaking to you in layman's terms.
Can you hear me? It was breaking up.
You hear me, Mr. Defendant?
He can't dumber it down anymore for you, my man.
Your mic is doing something odd. It's
Yeah, I thought it was just me.
Hang on just a minute. Mike, apparently my mic is breaking up again.
I hear it better now all of a sudden.
Yeah,
Okay,
you're all good, Judge. Don't worry. It's weird that he's addressing me directly, especially since this is a recording.
can you hear me?
Yeah, we can hear you better now.
Apparently it breaks up from time to time, and I don't know why.
Mike.
Okay,
So yeah, Your Honor,
hang on just a minute.
no problem.
Can you hear me now?
Yes.
Okay, is that better?
Yes.
Okay. Be on the right microphone. It's going through your other deal.
Okay, let me know if there are audio issues. I've had some issues with this.
No
Okay,
problem.
okay,
So
Mr.
yes, like I was saying, could you speak to me in layman terms? Because I'm not understanding.
Well, sir, those are as layman terms as it can be made. You have the obligation when you represent yourself to know the rules and to follow the rules, same as an attorney. Okay? You
How can-
filed your document on November 12th, 2024. What you're calling count 2, and you say, and I quote on page 2 at the bottom, count 2 of possession of controlled substance should be dismissed due to the illegal search and seizure of the alleged contraband. So what you're asking the court to do is to dismiss the charge of the contraband that was seized based on an illegal search and seizure. So
Yes.
you have filed a motion challenging the search and seizure. And that's
And
what
not
we're here to
to
hear
suppress
today.
evidence.
What's that?
And I said, and not to suppress evidence.
Well, that's what your motion is.
I never filed that motion.
Well, the
And I have
motion to dismiss is based on
No, big dummy. You never filed the motion to suppress, but that is the one thing that might have helped you. Probably not, but given the argument you're trying to make, that's what needs to be done. I like how he takes offense to the notion that he might have done something competently, which he didn't. We know.
you're asking the court to suppress the evidence based on an illegal search and seizure.
That's what I'm saying, Your Honor. I don't understand how I'm asking the court to suppress evidence if I filed a motion to dismiss an objection.
Well, that's what the motion to dismiss is. It's a motion to suppress the evidence. And if the state doesn't have evidence, then it gets dismissed.
Another candidate for remedial English class.
Okay, Your Honor.
All right. Are you ready to proceed on your motion?
Did you get my other motion, me responding to the state to declare the appeal unlawful?
Yes.
Okay. Is that motion going to be heard on the record today?
Well, we'll deal with that. You filed it 2 days ago. We'll deal with that after the suppression hearing that we're scheduled to hear today.
Your Honor, if I may, on that motion, it's filed untimely. We've already determined the appeal at our prior hearing was unlawful, given the nature of interlocutory appeals and the defendant's right to an interlocutory appeal at the last hearing.
Well, again, counsel, let's deal with the motion that we're here to hear, the motion to suppress, then we'll take up other issues. Okay? So is the state ready to proceed on the motion to dismiss?
Yes, Your Honor.
Go ahead.
State would call Trooper McCord.
Yes, sir.
Trooper McCord, will you raise your right hand? Tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes.
Thank you.
Mr.
Mr. Crane, you understand we're doing this test?
Correct.
And is it still your request to do this hearing by Zoom?
Correct.
Okay, go ahead.
State your name for the record, please.
James McCord,
And who are you employed by, Mr. McCord?
the Kansas Highway Patrol.
What is your job title there?
I am a Kansas State Trooper.
Okay, and what rank or designation do you have?
I am a technical trooper.
What do you do in your position as a technical trooper for the Highway Patrol?
My daily duties are to enforce traffic laws of the state of Kansas, and along with assigned to a domestic highway enforcement team, which goes after criminals traveling across our state using our roadways for illegal activities.
Okay. What kind of training have you received for your position at the Highway Patrol?
It started with a 20-week academy in January of 2002 when I was first employed with the Highway Patrol, then continuing minimum 40 hours every year.
As part of your training, have you been trained in the detection of controlled substances?
Yes, I have.
Okay. Does that training include detecting the odor of marijuana?
Yes.
What does that training look like? Do they like sit at a table in front of you and have you smell it? What do they do?
Well, it was during my initial training with the Highway Patrol. They introduced us to a lot of drugs. They identify like marijuana, cocaine, methamphetamines. They show us what it looks like, along with getting to be around the item where you can't smell it in raw and burnt condition, I guess.
And so you're familiar with the smell of both raw and burnt marijuana?
Yes.
What happened here? Did it go on me? Did it leave on me? Is the whole stream gone?
And as part of your training, have you been trained on legal standards like probable cause and reasonable suspicion?
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk
Yes, I
with
have.
Mike is
Okay, what kind of
experiencing
training
what
have
we
you
in
received
the
on those, like, legal
business
standards?
call apply.
It's been numerous trainings. We just went through blue to gold training on search and seizure of vehicles, property, and persons just recently.
In your position as a technical trooper for the Highway Patrol, are you a certified law enforcement officer?
Yes, I am.
And have you been at all times since you've been employed a certified law enforcement officer?
Yes, I have.
And does that include on June 20th, 2024?
Yes.
So let's talk about who you know. Do you know Caleb Crane?
I had a traffic stop with Mr. Crane. Yes.
How did you identify Mr. Crane at that traffic stop?
With a driver's license.
And would you recognize him if you saw him?
Yes, I would.
Okay, is Caleb Crane on Zoom here today, whose Zoom box says Jerome Crane? Is that the same person you stopped on June 20th, 24?
Yes.
Okay, what was the reason for that stop?
I'd stopped him for 80 miles an hour in a 60-mile-an-hour construction zone along I-70 at mile marker 157 here in Ellis County.
And what mile marker was that? Do you remember?
157.
What kind of car was it?
It was a black passenger car.
When you initiated that stop, what was your next step?
I made contact, and then at the window, I could smell the odor of marijuana coming from the vehicle.
Was that raw or burnt marijuana?
Raw marijuana.
Prior to that, let's back up a little bit. As you were approaching, did you observe anything inside the car?
Yes, I did. The passenger was digging around in the vehicle.
Okay. Is that unusual?
Yes.
What did that indicate to you?
Possible trying to use cover scent to hide narcotics in the vehicle or any illegal items that they didn't want me to see.
When you say cover the scent, what did you see that indicated that they were trying to cover the scent?
It appeared, in my perspective, that the passenger was spraying like an air freshener in the vehicle.
Okay. How strong? You had mentioned that you smelled the odor of raw marijuana. How strong was the odor?
It's an odor that you can it's very distinctive. I can't quantify. It's just the odor of marijuana.
Okay, would you say it was a strong odor or something less than that, weak? What?
It would be a strong odor.
Okay, so going forward to when you interact with Mr. Crane, what did you do once you started to interact with him?
I asked for his driver's license, proof of insurance, and registration paperwork. And at that point, they advised the car was a rental.
And so did they provide you with their driver's license and registration?
Yes, they did. The driver and the passenger both identified themselves with the driver's license.
Okay.
And the passenger advised his brother rented the car and they did not have the rental agreement.
Where was the registration?
In the glove box.
When they opened the glove box, did you observe anything?
Yes, I did.
What was that?
I observed a medical marijuana package.
What did you believe? What, if anything, did that mean to you that there was a medical marijuana dispensary bag in the vehicle?
That there would be marijuana in the vehicle.
Okay. So going forward from there, once you've obtained their driver's license and registration, what'd you do after that?
I returned to my patrol car.
Okay.
And then I had our Kansas Highway Patrol dispatch run both driver's licenses along with criminal history. Then I radioed for my partner to return as he just drove by westbound, come to my location.
Why did you call him back to your location?
Because I had probable cause to do a search of the vehicle and there were 2 subjects in the car.
What what factors at the scene kind of played into your probable cause determination that there was marijuana in the vehicle?
The odor of marijuana, then seeing a dispensary package in the glove box.
And at any point, did you see the car driven by Caleb Crane moving?
Yes, when it passed me in a stationary position.
How long before you conducted the search did you see it moving?
Yeah, approximately 4 or 5 minutes. That would be a guess.
Okay,
I wouldn't know the exact time.
sure. At the time you searched, did you have any reason to believe the car could be immobile?
That the car could be mobile?
That the car was immobile, that it couldn't move?
Well, the car was still running at the time when I got him out of the vehicle.
Your Honor, I don't think I have any more questions. Thank you, Mr. McCord. Trooper McCord.
Mr. Crane, do you have any questions of Trooper McCord?
It was really just like weird to me though, but because he said it was an air
Objection, he's
freshener.
testifying.
Hang on, I let him finish and I can determine whether he's asking a question or not, Mr. Becker.
It was just weird because he said air freshener, then there's a strong order.
He just wants to express his deep thoughts now. Although he's supposed to be asking a question.
The weed. It was just like, which one was it?
Mr. Crane, if you have questions of the officer, ask the questions.
Did you smell air freshener or did you smell marijuana, Trooper McCord?
I smelled both.
That's my only question.
Well done. Case dismissed. You're free to go.
Based on that question, Mr. Becker, do you have any redirect?
No, Your Honor.
Okay. Do you have any additional witnesses, Mr. Becker?
No, Your Honor.
Mr. Crane, do you have witnesses you'd like to put forth or evidence you'd like to put forth?
I wouldn't say evidence, but once again, one more question. I'm sorry about that. Trooper McCord, so have you seen a medical marijuana bag in the glove department? How do you smell
I wouldn't say evidence either. We finally agree on something.
marijuana through the bag?
Because the car had marijuana in the vehicle. Marijuana is a very strong, distinct odor.
Okay. You can continue, Your Honor.
So do you have any witnesses you want to put forth, Mr.? Okay.
No, I think I nailed it
Argument,
right
Mr.
there.
Becker.
My withering
Yes, Your
examination.
Honor. From the testimony today, we've heard Mr. Trooper McCord is a trained and certified law enforcement officer who's been trained in detecting controlled substances, including by their odor. He can detect the odor of raw marijuana. He can detect the odor of burnt marijuana. At the time of the stop, he was a certified law enforcement officer. And when he made the stop, he approached the vehicle, smelled marijuana, and there's no indication that the odor that the vehicle was anything but mobile. He saw it moving just minutes prior to the incident. The 2 points of law are really especially relevant here. First, under State v. Goff, that I cited in my response to the defendant's motion, the odor of raw marijuana alone is sufficient to provide probable cause and reasonable suspicion for the search. And the state is not required to show anything more than the mobility of the vehicle to establish exigent circumstances. This is a valid search under the probable cause plus exigent circumstances exception to the warrant requirement, commonly called the automobile exception to the warrant requirement. Also, I believe it suffices for plain view. He saw the medical marijuana bag. He smelled the odor of marijuana. He had lawful access because of the automobile exception to the warrant requirement to go in and seize those objects. And the smell of marijuana is immediately incriminating. Therefore, I believe that 2 exceptions to the warrant requirement are satisfied. This is ultimately a lawful search, and I don't really know that there's any other conclusion based on the testimony.
It's lawful law, Judge.
Mr. Frank, your argument.
Well, yeah, once again, like he also said, he seen me going 80 and a 60, but couldn't provide you with a speedometer. So it's like we really just sitting here. And
Seriously, what kind of prosecutor doesn't bring a speedometer to court?
it's just confusing me, like how he's just sitting here saying it's air freshener and it's marijuana. It's just too much back and forth confusion, if you ask me, Your Honor. That's not professional of him saying he's smelling air freshener, then he's observing weed and smelling marijuana.
So the Chewbacca defense.
Any additional argument, Mr. Cray?
No.
Marijuana makes you stupid, people. I know there's just a bunch of marijuana lovers out
Testimony
there.
from Trooper McCord is that he was a
But it makes
certified
you
law
stupid.
enforcement officer on June 20th of 24. He stopped a vehicle for speeding 80 in a 60-mile-per-hour construction zone in mile 157 of I-70, which is on the west edge of Hays in Ellis County, Kansas. When he approached the vehicle, he smelled the odor of raw marijuana and air freshener.
Ah,
The smell of the raw marijuana from the vehicle gives the officer probable cause that there is marijuana in the vehicle, which is illegal. He had observed the car moving, obviously, when it was going 80 miles per hour in a 60-mile-per-hour construction zone. So you have a movable vehicle. The smell of marijuana gives you probable cause to search the vehicle because it's a vehicle. The vehicle exception to the warrant requirement kicks in, and the officer is allowed to search the vehicle. As he asked the occupant for registration, the occupant opened up the glove box. He observed packaging from a dispensary, which also gives him additional probable cause of marijuana being in the vehicle. That would be under the plain view exception. So for both reasons, the officer had the constitutional right to search the vehicle. He searched the vehicle, and your motion to dismiss the possession of controlled substance due to an illegal search is denied.
I'm shocked. You know what that deserves, don't you? Let me find it.
Now, Mr. Becker, the defendant has filed a document titled Defendant's Response to State's Motion to Declare Appeal Unlawful. Are you wanting to, that was just filed on January 21st, 2 days ago. Are you wanting to deal with those issues today or set an additional hearing?
Your Honor, I think I would be prepared. I also filed a motion. I'm not sure if it's gone or a response to his response. So I guess properly I should have called it a reply. But I filed that this afternoon. I'm not sure if it went through to you yet.
That has not made its way into the court file yet.
Okay,
I don't know, the transcripts that I paid for, I still haven't received those as well yet.
Your Honor, while we're taking this up, can Mr. McCord be excused? I don't believe his testimony is needed anymore.
Yes, Trooper McCord is excused.
Thank you, Your Honor.
Thank you, Trooper.
And Mr. Crane, you had requested some transcripts from the court reporter. You had paid for the transcript from December 9th, 2024.
Mm-hmm.
Okay,
That was supposed to be for our court date before January 3rd, I believe.
and that was emailed to you on January 2nd, 2025.
I wouldn't say I had that in the email because I didn't have that for my court date.
He
And
wouldn't
on
say that.
January 9th, you requested a transcript from the January 3rd hearing.
Correct. And still haven't received those.
Okay,
I wasn't sent the link to pay for those transcripts or anything.
you have not paid for the transcript for January 3rd yet.
I know she haven't. I want to say her name's Lyle, if I'm not mistaken. Her last name.
Shock, she sent you the PayPal invoice both on January 13th and on January 21st, and you have not paid for the transcript.
I haven't received those.
Okay.
What does it say? What email she sent it to?
He just said I didn't get it or a link to pay for it.
Yeah, I haven't received those, and I had
Well,
told her,
that you'll have to take up with the
no problem.
court reporter. Okay.
She sent him a link. He didn't pay it. He doesn't have it. We all know what happened.
Mr. Becker, in looking at the defendant's document, he's titled Defendant's Response to State's Motion to declare appeal unlawful.
Yes, Your Honor.
I think he is referring back to the issues we dealt with on January 3rd.
In large part, yes, Your Honor. I believe that there are also some claims of procedural error, which I addressed in my reply brief, reply to his response. I believe the claims of procedural error are that the state did not respond to his motion to dismiss an objection. And that the court has held him to a motion to suppress that he's never filed. Or as I understand, those are his additional claims of procedural error.
Mr. Crane,
Yes, sir.
would you like to make argument on your motion?
Um,
This is the highest hearing I've ever seen. Oh,
well, my argument's in my motion as well, but 3, failure of prosecution to follow
which
proper
count?
procedure and due process, violation of constitutional due process. The prosecution, well, y'all had just declined my motion, but I had in my motion failures to respond to the defendant's motion to dismiss an objection violates the principle of fundamental fairness guaranteed by the Kansas Constitution Bill of Rights, Section 10 and the 14th Amendment to U.S. Constitution. Do asserting his rights during the preliminary hearing. Regarding to my motion to suppress, I had never filed that. The failure to address, well, once again, y'all just addressed my motion to dismiss.
Regarding to my motion to suppress.
It further underscores the need for addressing the defendant's legal rights and claims.
Okay. You filed a motion challenging the probable cause at
Yes.
preliminary hearing.
Mhm.
The court reviewed the transcript of preliminary hearing. Court found there was probable cause for count 1. Under the standard of probable cause, was the crime committed, and probable cause the defendant committed the crime. Court found that the preliminary hearing testimony of the officer was sufficient to establish probable cause of identity fraud as contained in count 1 of the complaint. That is the level 8 non-person felony. The misdemeanor in count 2 is not addressed at preliminary hearing because it's a misdemeanor. And the probable cause preliminary hearing, that is a statute that was created by the Kansas legislature. Probable cause hearings are not constitutional in nature. They are created legislative acts. Kansas legislature created the act of a probable cause hearing called a preliminary hearing to deal with felony offenses. The state provided sufficient evidence to bind you over on count 1, the felony. Count 2, possession of marijuana, is not addressed because misdemeanors are not addressed at prelim. Misdemeanors go straight to trial. There is no need for a probable cause hearing on misdemeanors. So the court ruled against your motion to dismiss for lack of probable cause on the felony offense. You then have argued that the state could not add count 3, the speeding infraction. The state can add charges for whatever the evidence supports. And when it's a misdemeanor or an infraction, the state can add that without there being a probable cause hearing. And the state added count 3, speeding, a traffic infraction.
After the fact.
It can be charged up to the jury coming back and concluding the case, as long as it doesn't charge additional charges that you were not put notice on. You've been put notice on for the speeding offense well in front of a jury trial. So yes, the state can add additional charges after the initial charging document.
Okay.
State asked for and received permission to add count 3 at the preliminary hearing. So that motion was overruled. You have
Okay.
asked for the search of the vehicle to be declared illegal. We've just had the suppression hearing. The court has denied your suppression hearing. So that has been denied by the court. You're wanting to appeal the
Correct.
over at preliminary hearing, and you're wanting to appeal, quote, the probable cause of the officer. Those are not appropriate interlocutory appeals under Kansas procedural law. You need to proceed to trial on the case, and then you can challenge those issues on appeal, but not till you have proceeded to trial.
But
They're not subject to an interlocutory appeal.
it says right here, interlocutory appeal recognized for substantial rights. Kansas law allows for interlocutory appeals where substantial rights are at stake as indicated. State versus Johnson, 293 Kansas, 543 in
As
2011.
indicated in the statute, but the statute authorizes who can file an interlocutory appeal. And the defendant does not have the right to use interlocutory appeal to challenge probable cause at preliminary hearing or a denial of suppression of evidence. The correct procedure is for you to then proceed to trial. If
That's
you are
going against my constitutional right.
if you are convicted, then you can appeal those issues, but you cannot appeal them prior to trial.
I give him credit. It took him 3 tries, but he finally said it correctly.
Interesting.
Interesting. Not really. Mostly it's
Now,
boring.
in your response, that is what you've got down as number 2, legal framework for appeal. Number 3 states failure to follow procedure.
Your Honor. So that's
Yeah.
not going against my constitutional right, though.
What's that?
I said me not being able to
No, the interlocutory appeal, again, is a statutory creation, and the legislature set forth the interlocutory appeal. The defendant does not have the right to an interlocutory appeal on a bind over at preliminary hearing or a denial of suppression of evidence.
Okay.
Okay?
You should maybe have an interlock device. That's about as far as you can get with a word.
Issue 2 or issue 3.1 is your due process, which we've talked about. 3.2 is safeguards under 223208 with electronic communication, which we're having your Zoom hearing. At your agreement to do that.
Correct.
3, lack of accountability. Again, you can challenge all these charges at a trial. Number 4, basis for motion to dismiss and current appeal. Count 1, again, you're talking about the identity fraud. The court has found probable cause for that to proceed to trial. For 2, you're trying to challenge the hearing we just had on the suppression hearing, and that's denied. Count 3, the speeding. The officer does not need to issue a notice to appear at the time. He can he can proceed with what's called a long form charging document rather than a notice to appear. He added the charge at preliminary hearing and then filed it as count 3, which is what's referred to as long forming it. So you do not receive a notice to appear after they have filed an information or a complaint. They must amend their information or their complaint, which the state has done. So regarding your speeding infraction charge, that is denied. Issue number 5, procedural irregularity. Again, you're referring to the fact that you did not call your document a motion to suppress. What you called your document was a motion to dismiss based on the officer seizing evidence illegally. That is a motion to suppress, which the court has just heard and ruled on. Wanting to postpone your arraignment to proceed with the interlocutory appeals, which you're not entitled to. So that request is denied. Are we ready for arraignment?
The state is, Your Honor.
Mr. Crane, you've got a copy of the amended complaint.
I want to say.
Did they just say?
Mm. My mother's gonna grab it for me real quick, but I'm not ready for arraignment.
You're not ready for anything.
Your Honor, could I, moving forward, could I get all my motions filed under certified mail so it won't be any confusion?
You've already filed your motions and they're in the court file.
Confusion wasn't your problem. The court addressed everything you have, even though it was procedurally deficient. The problem was the substance of your motion sucks, and you don't know what you're doing.
Yeah, I got my arraignment right here in front of me.
What's that?
I said I had the journal entry of motion here is an arraignment right here in front of me. That was electronically filed on January 3rd.
Yeah, that's a bind over for arraignment.
Could you break down the word arraignment for me?
An arraignment is when the court addresses what you're charged with and you actually enter your plea. It's a procedural step.
Could you break that down
begins
for
the
me, Judge?
speedy trial process. Can you see the amended complaint?
I'm going through it.
That was filed on October 3rd.
I'm trying to see where it says October 3rd. It says the 3rd of January.
3rd of October. I'm sharing my screen. Can you see the document?
Hold on wait a second. No, I don't have this, Your Honor. I don't know why I don't have this.
It was filed that same day as your preliminary hearing.
Yeah, I don't have this.
Can you see it on the screen?
Yes.
Okay. In the amended information, it charges count 1 that on or about June 20th, 2024 in Ellis County, Kansas, Caleb Jerome Crane did unlawfully and feloniously alter, amend, counterfeit, make, manufacture, or otherwise replicate any document containing personal identifying information with the intent to deceive. That is identity fraud, a severity level 8 non-person felony in violation of KSA, which is Kansas Statutes Annotated 21-6107, sub B, sub 2, and sub C, sub 2, with an anticipated criminal history score of I.
I want to dumber down the ticket. I want to fight
If
that.
convicted of count 1, a level 8 non-person felony, you are subject to a minimum of 7 months with no criminal history, to a maximum of 23 months if you have 3 or more person felonies in your background. It is presumptive probation if you have less than 2 person felonies in your background. It is presumptive prison if you have 2 or more person felonies. And a level 8 is also subject to a fine of up to $100,000. Do you understand the potential punishment?
Yes.
Okay.
Question about that though. Trooper McCord said I presented my driver's license. So I'm kind of confused on count 1, but
It doesn't have to do
You're
with the driver's license. It has to
confused
do
on
with the
everything.
other documents found in the car.
okay, no problem.
Okay. So how do you plead to count 1? You can plead guilty, you can plead not guilty, or you can stand mute, in which case the court will enter a not guilty plea for you. So how do you plead to count 1?
Mute.
So you're standing mute, so the court will enter a not guilty plea on your behalf. As to count 2, you are charged that on or about June 20th, 2024 in Ellis County, Kansas, that Caleb Jerome Crane did unlawfully and knowingly possess a quantity of marijuana, a Schedule I controlled substance as designated in KSA 65-4105 sub D sub 17 and amendments thereto, and / or its active ingredient tetrahydrocannabinol, a Schedule I controlled substance as designated in KSA 65-4105 sub H sub 1 and amendments thereto. Charge is unlawful possession of marijuana, a Class B non-person misdemeanor in violation of KSA 21-5706 sub B sub 3 and sub C sub 3 sub capital A. A Class B misdemeanor can result in a county jail sentence up to 6 months and a fine up to $1,500. Do you understand what you're charged with?
Mm-hmm.
How do you plead to count 2?
I'll plead guilty.
You're pleading guilty to count 2?
I'll plead guilty.
Okay. Count 3.
That shocks me.
That on or about June 20th, 2024 in Ellis County, Kansas.
Well, there we
Caleb
go. We got a
Jerome
conviction.
Crane did unlawfully drive a vehicle at a speed to its 80 miles per hour in excess of the maximum lawful speed to its 60 miles per hour in a construction zone. That charge is speeding. That is a traffic infraction. in violation of KSA 8-1558. It is subject to a fine, and because it's in a construction zone, the fine is doubled in Kansas.
And what would that fine be?
Mr. Becker, are you aware of the fine? It would be 20.
I can be in just one moment, Your Honor. It would be a $210 fine.
420.
Is that before or after you?
That is after it doubles.
Okay, so it's $105 and it doubles to 210.
Yes.
Okay. So in count 3, you're subject to a fine up to $210.
Okay, I'm gonna plead mute.
Stand mute.
Yep.
Okay, the court will enter a not guilty on your behalf on count 3. So as to count 1 and count 3, are you requesting a jury trial or a bench trial?
Can you break that down for me? I don't understand.
A jury trial means we would bring in 12 citizens who would qualify as a jury, and the jury would decide whether you're guilty or not guilty of count 1 and count 3.
And the other one is?
Or you can try it to the bench, meaning you come in and you and Mr. Becker present your case to a judge rather than to a jury, for a judge to decide factually if you're guilty or not guilty versus a jury deciding factually whether you're guilty or not guilty.
We wouldn't be able to do this on Zoom?
No. This will need to be done live, whether it's a jury trial or an in-person trial, we'll need to do that live.
Jury.
You'd like a jury trial?
Mm-hmm.
Okay. How long do you anticipate needing for that jury trial, Mr. Becker?
A day, I think, would be sufficient.
I need more time than that.
How much time do you think you need, Mr. Crane?
6 months.
No, we're talking about how long of a trial we're going to have. Not when the trial is yet, but how long of a trial. Mr. Becker is indicating we can do the jury trial in 1 day, in which we pick the jury, make argument, opening statements, present the evidence, make closing statements, and have the jury deliberate.
I say 2 days.
You think it's going to take 2 days?
I say a week with the slow talking judge and this
We'll
big
set
dummy.
2 days just as a precaution. Jess, we're going to need a 2-day jury trial.
Anxiety leads to constipation. Anxiety leads to constipation.
That you would be available on June 10th and 11th.
Can we push that back a little? Give me
Well,
one.
why would you need to push that back?
Just get more time, money. I gotta get out there.
Well, that gives you 5 months almost.
Pick up a couple more shifts at the Taco Bell.
I know I still be having to pay my bills and etc. I wouldn't really, you know what I'm saying?
The problem is we have to get you tried within speedy trial.
Could I get 2 more months on top of that 5?
You want to waive speedy trial? Because that's what you're doing by continuance.
Judge, it looks
your
like speedy
request.
trial's July 22nd.
So we need to get you scheduled before July 22nd, so we don't violate your constitutional right to a speedy trial. Jess, do you have any days other than June 10th and 11th
We're getting there, people.
in that time frame?
I'm committed now. We're going to the end of this
Could I
hearing.
do July 19th?
Hang on.
July 19th is a Saturday.
Okay.
Judge, you would have time the week of July 7th. You could do July 9th or July 10th.
9 sounds good.
So July 9th and 10th? Does that work for you, Mr. Becker?
Yes,
Or
Your
the,
Honor.
or the 10th and 11th, whichever.
I'm done.
Mr. Crane, do July 9th and 10th work for you?
Yes, what time are you guys thinking?
Well, you'll need to be here. We'll start each day at 9 o'clock, but you'll need to be in the courtroom at 8:30.
I was thinking 9-ish. Does that work for you?
So July 9th and 10th?
July 9th and 10th.
That was polite, but funny.
Need to have a pre-trial 4 weeks prior to that, Jess.
Do I need to be there for that?
Yes, you'll need to be here in person for the pre-trial conference.
Nah, it's just your case. Don't worry about it. We'll just talk to your non-existent attorney instead. How's that?
Judge, June 9th is your motion day. I'm sorry, we're in July, July 9th. Yeah, that would be right. It's about 4 weeks prior.
Now, I know you had some time on June 10th. That's what we were looking at for jury.
Yeah, so your motion day is June 9th. We could put a pretrial there.
Okay, 9th, 10th, or 11th. Let's save the 10th and 11th for other trials.
Right,
Is
right.
that a Friday?
No, it's a Monday.
You said June 9th and 10th as well?
June 9th
June 9th
trial.
for the pretrial. 1:30, Judge?
And I gotta be out there.
Yes.
Could we get that a little earlier or no?
You need to be in person 1:30 on June 9th for pretrial conference.
I couldn't get that earlier or no?
Earlier in the day, Mr. Crane?
Yes, ma'am.
Judge has time in the morning of that day. You would prefer a morning setting?
Yes, ma'am.
Okay, we could do a 9 o'clock.
And then what time for July 9th and 10th?
You'll have to be here each day, ready for trial at 8:30.
Okay, I'm writing it down.
Judge, do you also want some sort of a status conference prior to the pretrial or?
Yeah, let's make sure we have our pretrial nailed down here.
June 9th at 9 a.m., Judge?
And that works for you, Mr. Becker?
Yes, Your Honor. I don't have anything set out past March yet, so.
And Mr. Crane, June 9th at 9 o'clock?
Yes, Your Honor.
Okay. And yes, we need our motions / jury conference prior to that. So when do you need to send out your notices?
Yeah, will that be in person or by Zoom, Judge?
That one will be by Zoom.
Your criminal motion date for May is May 12th. In that morning, Judge, you would have time?
What time?
9 a.m.
So May 12th, 9 o'clock. That's jury questionnaire and motions hearing.
That will be by Zoom.
That one's by Zoom. If you want it by Zoom, Mr. Crane, we can also do it in person if you want to do it in person.
Could you repeat that for me? So I got to.
Oh, sweet
May
Jesus.
12th,
What?
we'll have a hearing to make sure we're using the one-page juror questionnaire or the extended questionnaire, and any other motions that either party has filed prior to trial.
Said either
You
motion.
want to do that in person, or do you want to do that by Zoom?
Okay, I heard what you said. You said either party's motions in each questionnaires.
Jury questionnaires, normally we use a one-page questionnaire. If there are special circumstances, either of the parties can request an extended questionnaire, but you need to submit reasons why we would use an extended questionnaire versus the standard one-page questionnaire. And then any other motions that either party has filed concerning the case that need to be heard, we can take up at that time.
Well, yeah, I do that on Zoom. What time?
9 o'clock.
Okay, no problem. Well,
I'll roll by in the Mike Mobile. Make sure he's ready for court.
We have our juror questionnaire conference and motions
Put a
hearing
tie on him.
May 12th, 9 o'clock by Zoom. Our pretrial conference is June 9th, 9 o'clock. That is in person. And our jury is July 9th and 10th, and that is also in person.
Judge, could you repeat all that?
okay, no problem. I'm free to go, Your Honor.
Are you still wanting to continue to represent yourself in this matter, Mr. Crane?
As of right now, yes.
Okay. And you believe you have the ability to represent yourself?
As of right now, yes.
Okay.
If I'm gonna hire an attorney, I'll let you guys know.
Let us know, please.
Fill us in.
No problem.
As to count 2, you pled guilty.
We'd probably find out from the appearance.
The court will accept your guilty plea. We will address that at the conclusion of the jury trial.
No problem.
Okay? And what I mean by that is if we have a jury, if you are found guilty of count 1, the felony, then you'll have to undergo a pre-sentence investigation, and we will move the misdemeanor sentencing in conjunction with the felony sentencing. If you're found not guilty by the jury, we'll take up sentencing right after the jury verdict. Okay?
All right.
And Mr. Becker, you'll do the journal entry from today?
Yes, Your Honor.
Okay. Any questions you have, Mr. Crane?
Nope.
Anything further for the record today, Mr. Becker?
No, Your Honor.
Anything for the record today, Mr. Crane?
No, Your Honor.
Okay. We will see you then on May 12th, 9 o'clock our time by Zoom. For the next hearing.
All right.
Okay. Thank you all.
Thank you.
So you want to learn about American accents? Well, shoot, I'd say you got plenty to choose.
All right. Well, that was something. We got something that Wild Goose Chase by Alyssa. She was wondering if it was a SovCit. I'm still not sure. He didn't say a lot of SovCit stuff. He started sounding like a SovCit, but then he just slipped into garden variety, dope smoking stupid. I think that's ultimately where we are. But I might just leave it up there. I might leave it up there. SovCit, stupid, or both. Sounds like a title. All right. Thank y'all for coming out. I got to hit the hay. I need a midday nap. I get up at the crack of dawn literally to monkey around. And then I streamed, and here I am. All right. Thanks for coming out. I'll see y'all soon.